So the Supreme Court has issued an order in a critical Second Amendment Preservation Act challenge that was pending in front of them. So let's talk about what is happening now in this critical case. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. And also, I just wanted to wish everybody a Merry Christmas. I hope you had an amazing time with your family and friends. But again, thank you guys so much for all of your support of what I do here on the channel and what we talk about here in these type of two-way topics. Now, as I mentioned in the intro, in this video, we're going to be talking about a huge and very significant Second Amendment protection case that was seeking emergency Supreme Court review. This is a case dealing with a state's Second Amendment Preservation Act, also known as their SAPA law. We've discussed this case before because in the past, the Supreme Court issued an 8-1 order denying a stay which would have protected Missouri's SAPA law. This case recently went back in front of the Supreme Court and we got an answer from the Supreme Court. The Supreme Court in a recent order list denied once again emergency review to this Missouri SAPA case, but this case is not yet done based on some of the things that were raised by the Trump DOJ in that cert petition. Now, you might remember that in this case, the Trump administration continued to argue that the SAPA law is invalid in some of its applications and that the Supreme Court should deny review to this case. However, at the same time, they also stated that if the Supreme Court denied review to this case, the Trump DOJ would release some of the permanent injunction and complete injunction that was received by the Biden administration at the lower court level. The administration told the Supreme Court once this case got back in the hands of the lower court, the Trump DOJ would release part of that judgment. Missouri responded to that by pointing out that the concessions made by the Trump DOJ are exactly why the Supreme Court should have granted review to this case after that conference. And Missouri also raised some serious concerns about maybe the Trump DOJ not staying true to their word once this case is denied and once it's got back in the hands of the lower court. Maybe the Trump DOJ would not actually stay true to those promises. But unfortunately, the Supreme Court took the administration's word and denied review to this case. That kind of left the door open for the administration to remove some of the prior ruling that they argued, in favor of that denial request. However, to this point, even after the denial, the Trump DOJ still has not moved for the lower court to remove the complete injunction that was issued in favor of the Biden ATF and the Biden DOJ. Now, this lawsuit, you may remember, revolves around a 2021 Second Amendment Preservation Act passed in the state of Missouri. That law set the state's interpretation of the Second Amendment and set restrictions on the support and funding that the state would provide to federal agencies in their attempts to enforce federal laws that violate the Second Amendment. The law prohibits Missouri's officers and agents and government officials from helping federal agents who are attempting to enforce those inconsistent laws. The law also created a civil remedy where any resident of the state of Missouri could sue a Missouri official or officer or agent if they help to enforce a federal law that the state believes violates the Second Amendment. So the law aimed to give the true enforcement powers to the residents instead of any state officer or agent. Now, in this Missouri case, the district court on review ruled in favor of the then Biden administration, striking down the Missouri SAPA law in its entirety. Now, in response to that, the state of Missouri appealed to the 8th Circuit, and Missouri at that time also wanted a temporary stay on that lower court ruling, which put a permanent injunction on the entire SAPA law. And at that time, the 8th Circuit did not want to grant that, so that led Missouri to go to the first time to the Supreme Court to seek an emergency stay. However, on review, the Supreme Court issued an 8-1 order denying that emergency stay. It was only Justice Thomas who was in favor of granting that stay, which would have allowed the SAPA law to remain in effect while this case was currently being appealed. Now, after the Supreme Court denied review to this case, it went back in the hands of the 8th Circuit, who quickly held arguments in this case, and then the 8th Circuit ultimately ruled in favor of the federal government, striking down the SAPA law once again. But now Missouri, again, like I mentioned, filed for Supreme Court review, and they wanted the Supreme Court for a second time to take a look at this and potentially step in. Now, one of the big things that Missouri pointed out to the Supreme Court was that the 8th Circuit essentially said that the structure and operation of this law in Missouri is valid, but ultimately the 8th Circuit struck it down because they did not like the underlying purpose, which was to protect the Second Amendment. Missouri argued that the 8th Circuit went against clear precedent and found that the state's officials could be sued because the court believed that the state played a role in some enforcement of the law by simply complying with the state law, which told them to do nothing. Essentially, the 8th Circuit found that compliance and non-action was still enforcement, and therefore the state of Missouri could be held accountable for this SAPA law. Now, this law was originally opposed by the Biden administration, but like I mentioned, the Trump DOJ got control of this when the administration turned over. And initially, the Trump DOJ kind of stalled the response at the Supreme Court level for multiple months. But recently, we received the answer from the Trump DOJ. And in that response, the Trump DOJ continued to argue that the SAPA law is invalid and that the lower court got the decision correct. However, like I mentioned, at the same time, at the Supreme Court level, they argued to the Supreme Court that if the court denied review to this case and it got back in the hands of the district court, the lower court, the federal government here would then ultimately dismiss some of that total injunction that was received by the Biden administration. They argued in the response that having reevaluated this case, the United States has concerns about whether the judgment below extends too far and enjoins applications of the act that do constitute mere non-enforcement of federal law protected under the anti-commandeering doctrine. And those concerns are exacerbated by the uncertainty in this pre-enforcement posture about how certain provisions of the act will be applied and about whether the provisions on which the Eighth Circuit focused are indeed inseparable from the rest of the act. They stated, given these concerns, the United States has decided that it would acquiesce in narrowing the scope of the judgment when the district court regains jurisdiction over this case. So after stalling the case for multiple months, the Trump DOJ responded by continuing to argue that some of the SAPA law is still invalid and that the Supreme Court should deny review to this case. And at the same time, the administration believed also that the pre-enforcement judgment issued by the lower court may have gone too far. And they agreed to concede and narrow potentially some of that judgment down below in the lower court if the Supreme Court denied review to this case. And unfortunately, the Supreme Court sided with the administration in this case. In a recent order list, the Supreme Court decided to deny emergency review to the SAPA challenge. Despite that denial in this case is not yet done and it will still move forward at the lower court level. So there may be some ways in which the SAPA law will be able to be implemented in some of its regards and some aspects as this case moves forward to a final merits judgment. Now, there is kind of a larger concern, and that is that at this point, the Trump DOJ has not moved for the lower court to remove the total injunction like they stated they would do at the Supreme Court level. Recently, a notice from the Supreme Court went out to both the Eighth Circuit and to the lower court, and it went to the Missouri District Court that's going to now have control of this case. And that notice simply stated that the court today entered the following order in the above titled case, that the petition for writ of cert is denied. So the denial now is final, and all of the lower courts have been made aware that the case has been denied and it needs to move forward at the lower court level. We will now see if the Trump administration stays true to their word or if they're going to kind of go back on that promise. But I will state to this point, there has been no movement by the Trump DOJ to release that total injunction that they got, that total block that the Biden DOJ actually got in this case. You know, that was a statement that the Trump DOJ made to the Supreme Court saying that if you deny review to this and it gets back in the hands of the lower court, we're going to release some of this judgment. That's what we plan to do. The Supreme Court denied review, but to this point, the Trump DOJ has not fulfilled that promise. So unfortunately, Supreme Court once again denied review to this case and denied getting involved in this issue, but there's still hope and positive movement, potentially in favor of releasing some of that judgment and some of the Missouri SAPA law going into place. But again, I will note to this point, the Trump DOJ has not fulfilled that promise. So that is something we're going to want to keep a close eye on to see if that actually happens like they said it would to the Supreme Court. So that's what's currently going on in this critical case. As it develops more, as I get more information, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All those things help to fuel the algorithm. Also, you can check out one of the two videos here on the screen that the YouTube algorithm thinks that you'll find helpful. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.